Hey guys, welcome back. Today we have a very interesting session. You already know our speakers. They were also speakers in yesterday's session. Matthew Chaco and Ankita Hariramani of Spice Root Legal. So as you guys were able to tell yesterday, they're the subject matter experts when it comes to the regulation around account aggregators. And today's session will be focused around the process of applying to become an account aggregator and also becoming an FIU. Who can become an account aggregator, who can become an FIU, and how. This is very relevant to all of you who wish to actually, build for production and take some projects live in the real world. So we hope that this session is useful, and we know it will be. So just like yesterday, please do engage by putting your questions in the questions tab or raising your hand to actually come on stage and interact with our speakers. So welcome Matthew and Akita, and thank you guys for being here.
Thanks, Ariman. I think we'd like to apologize on behalf of Vinay. Vinay is the general counsel at Setu and was supposed to join us today. He's unfortunately not keeping very well. But we will try and drag him on for next week's weekend session if he feels better. That said, welcome to what is now going to be a slightly more technical, slightly less freewheeling session on how to become an account aggregator or an FIU. Nothing on an FIP because obviously I'm hoping nobody in the audience wants to is from one of the banks. But if there are, we can have a conversation then. But by and large, this is a discussion on what are the requirements for applying to the RBI to become an account aggregator. How is the process? What time does it take? Yada yada, all of that. And then in the second half, what are the requirements to qualify to be a financial information user? What are the applications you can make to the four regulators? Um, what will that mean for your business? What are the compliance requirements? How much time will it take? And how can we help you shorten that space? What are the easiest applications to make? All of that. As always, questions if you want to, please interrupt. I think Ariman is going to call people onto the video. If that's not possible, we'll repeat on chat. But it's always better to have a discussion. So if someone wants to spend 5 minutes talking about a particular problem that they have or some way they think about the regulatory process, please pop by, get into the discussion. Let's talk about it because others will learn from that as well. With that, shall we begin, Ankita?
Yeah, sure.
You want to screen share?
Yeah.
I have a Finding Nemo teacup, but anyway.
Okay, I'm just gonna screen share. Okay, I'm having some trouble sharing my screen.
Okay, I guess we can even do it without PowerPoint.
Yeah. So I think we had touched upon a few aspects of the entire account aggregator, their roles, their responsibilities yesterday as well. I'm not sure how many people attending this session were there during the session yesterday as well, but just to make sure everyone's aware and everyone's aligned, let me just quickly run over these concepts once before I get into the entire detailed application process. Now, account aggregator, the ecosystem, essentially three parties, three important players in the entire framework. One, of course, the main account aggregator itself, which is the NBFC, which acts as a data blind consent pipe between the users and the providers. Then you have your financial information providers, which are essentially entities that can share financial information. As of now, the RBI has a very specific definition of who a financial information provider is. This includes banks, it includes NBFCs, it includes asset management companies, depository participants, insurance companies, insurance repositories, as well as pension funds. Now, while this is the current definition, the RBI has left it open that from time to time they may inform and they may identify other entities who may possess financial information to become a part of this entire framework by sanctioning them as a specific financial information provider. Now, who can be a financial information user? Which means who are the entities who can actually access financial information from these providers through the AA pipe. These are called financial information users. As of now, the RBI has a very clear definition. As long as you are an entity that's regulated and governed by one of the four regulators, which are the RBI, the PFRDA, the IRDA, and the SEBI. So, as long as you're regulated and governed by one of these four sector regulators, you are a financial information user. Now, a lot of, and I think before I get into the AA application process, I thought it'll be better we discuss the FIU process because that's fairly simple and there isn't too much debate there yet. But in order to be a financial information user, you have to be regulated and governed by one of the four sectors. So that aspect needs to be clearly fulfilled. Now, we often have a lot of fintechs coming to us and asking questions on, how they are not regulated but would want to be able to provide their technology and their services to FIUs or would want to participate in the ecosystem and would want access to financial information. Now, there are two ways to go about this, and I did touch upon this in the last session as well. One is, of course, you need to try and get a license, right? Now, in our experience, the two most simplest registration processes would be, of course, the registered investment advisor license from the SEBI and the retirement advisor license from the PFRDA. Now, between the two, given that the SEBI is a slightly more stringent and a regulated framework with respect to investment advisory there, the compliance requirements for a registered investment advisor are slightly higher. The timelines, even to get the license, is slightly longer as compared to a retirement advisor under the PFRDA. The net worth and the capital requirements are also higher, right? So for a registered investment advisor, you need to have a capital of 25 lakhs. Whereas for a retirement advisor under the PFRDA, it's practically just a security deposit of 50,000. So the process for a PFRDA license is fairly quick, is not very complicated to get. By and large, both licenses will require you to maintain some basic compliance norms. For example, appointing compliance officer, ensuring that if you are providing any other business that's separated from your investment advisory business. So those are basic norms that will have to be maintained by either party. But between the multiple licenses that fintechs could apply for, these seem to be the most easier ones to get to become a part of the system. The other way, of course, is that if you are a technology provider that's working with a registered and a regulated entity already, so if you are working and if you are providing services to an FIU for probably some credit algorithms, if you're providing some technology support to them, some KYC processing to them, then it is essentially through the FIU you can access this information. So the FIU during the entire consent artifact process needs to clarify the data of the parties who will have access to this information. So it's your right to access the financial information there comes from the FIU and not the legislation per se. It's your contractual arrangement that you have with the FIU in that case. I hope that helps. Do we have any questions on the FIU? Because I thought that's usually the most debated bit. Okay.
Wait, so Ankita, just to summarize quickly what you said, FIUs are entities which are regulated by any of the four regulators mentioned in the notification: RBI, PFRDA, SEBI, and IRDA. Any license which is under those would be would entitle you to become an FIU. Once you become an FIU, you can get the entire spectrum of data from the account aggregator, right? Whatever you need. So you're not restricted if you are, if you are an investment advisor, you're not restricted in the AA architecture to get information only related to investment advisory. Once you get access, you are an IA, you are an FIU, then you can do whatever you want with the architecture. I think the thought process is that once you're regulated by these regulators, you are subject to at least a little bit of data protection norms to make sure that you don't kind of play truant with data. That's the only intention. I see, Ankita, that we have some questions popping up.
Yes.
Can you elaborate a bit on the contract for a fintech operating with an FIU? Is that similar to a business associate agreement? Um, would this gentleman like to come on board? I'm not sure if I understood the question, so it'll be better if you can kind of speak it out so that I can ask you questions back. Hariman?
Yes, I will bring anybody onto stage if they raise their hand by hitting the button on the right. Then I can bring them on stage.
Yeah, but in the meantime, while you do that, let me handle Mehul's question, which is whether a license issued by the RDA would hold any problem if we use the data for lending or payments. Absolutely not. Not under the account aggregator ecosystem rules.
Okay, I'm bringing Satya on stage to explain his question.
Perfect.
Hi.
Hi, Satya.
Yeah, so the question is about just a minute ago we heard that if there is a contract between a fintech that wants to operate with an FIU, that's the contract between the FIU and the fintech, right?
Yes.
So in the health sector, we have seen something called a business associate agreement. What that means is you are, let's say, if you are working as a subcontracting company or any notion of a subcontract, meaning if you handle data on behalf of another company, you are supposed to take the same kind of caution on dealing with the data, and it comes with certain omnibus rules here in the West that basically says you're as liable as the other company, and that is enforced via this business associate agreement. Is
Right.
that something similar to that?
Yeah, so typically in the more mature markets, um, in the more mature sectors, in larger companies, the agreement you would have would be either a data transfer agreement or a data processing agreement. Now, in the US, I presume your BA is from the US.
Yes.
In the US, a BA is used for smaller companies like startups, and they incorporate the broad framework of a DPA or a DTA without the details. In India, yes, similarly, you would have what we see from our end is we prefer if you actually go in for a full-length data protection, data processing agreement, especially if you are acting as a service provider to an FIU.
Okay.
Is that what you would be doing? Yes, service provider.
Yes, something along those lines. So, is this truly a contract between the two companies, and or does it have any application process or a compliance process with the government entities?
So,
Absolutely. Go on, Ankita.
sorry. Yeah, so Satya, while there might be no application process for you, your arrangement with the FIU is absolutely contractual. The FIU is governed by the RBI when they outsource any service to a technology service provider. So
Hmm.
the FIU as such would be required to have an agreement in place that would cover a few important aspects, like they will want to ensure that you have a business, a disaster recovery process in place, a business continuity plan in place,
Okay.
whatever obligations are on them with respect to data and record keeping that is essential, they would pass that on to you as well.
Okay.
So the FIU is regulated. Whatever stems from the regulations for the FIU that may trickle down to you as an entity based on the service that you're providing. And of course, in order to cover liability, the FIU may have some contractual terms on liability and indemnity. But in the eyes of the RBI, the FIU would be responsible for your actions.
All right. Thank you.
Yeah, so I think to summarize what Ankita is saying again, that FIU is going to be a painful person. If it's well advised, that contract will be long and difficult.
Okay.
Perfect. Does that answer your question?
Yes. Thank you.
Aryaman, I think there is a Shiv Prasad who wants to join.
Yes, I will just bring him on.
Hello, hi Matthew, hi Ankita. Can you guys hear me?
Hi, Shiv Prasad.
Hello, hello.
Thank you for the feedback. I got the point that we are a fintech based out of Hyderabad, and I understand that we should have a contract with an FIU for us to leverage the account aggregator system. But I have a quick question follow up to what Satya also said. Now, we in our workflow, we also have a downstream company where we depend on to compute what we are doing. So it's not just our relationship with the FIU, but there is again a downstream company we want to work with, which kind of extends the AI model to something like writing data on a blockchain, for example, where we don't have infrastructure on blockchain today, but we want to leverage somebody else who's our partner, who we've worked with in the past, to run through the whole process. Now, how would they be compliant? I mean, there's one relationship between us as a fintech and the FIU, but then again, there's a downstream partner who's like a third party who we are leveraging to write some information and then get it back. So, how would that as a compliance work on?
So you'll need a fairly detailed legal architecture for that. What would happen typically, everything remaining the same, is
Mm-hmm.
that the FIU would pass on their liability to you
Right.
by contract,
Yep.
and you will pass on your liability to the blockchain company by contract.
Okay. Okay.
Now blockchain has additional complications which it would not have if this was not blockchain,
Mm-hmm.
because of immutability.
That's
Right?
true. Yeah. Yeah.
What if the FIU is asked to delete the data?
Right.
Masking enough?
Mm-hmm.
What masking protocols are enough?
Right. Right.
So be careful with blockchain. Its compatibility with the AI architecture needs to be clarified by the RBI.
That's
But for
the answer.
everything else,
Yeah.
there are fairly simple solutions.
Yeah.
Also, Shiv Prasad, just to add in there, again,
Sure.
the FIUs are a little particular about the activity that they are actually outsourcing
Sure.
and the subcontractors that the outsourced entity would then use. In most cases, you would first be required to take consent and get an approval to be able to outsource it to any other third party that you may be working with.
Absolutely. Absolutely.
So, and again, I'm not sure how many banks and FIUs would be comfortable with blockchain at this stage
Sure. Sure. Mm-hmm.
And
without any instructions.
we're just telling you because we're working with a few of them on blockchain and they are very, very difficult.
Right. Right. Now that's the kind of feedback I wanted. Thank you so much. I got the hang
Perfect.
of it.
Thank you.
Really appreciate it. Thanks.
Thank
Thanks.
you.
I think we have a few more questions. Nikhil, of course, I expected you up there first. Haryaman, shall we get Nikhil from FinRK in?
Sure, although he hasn't raised his hand yet. If he does, we can.
Okay, but if not, shall we? Someone's raised their hand.
Here he is. Nikhil is with us.
Yeah, hi.
Perfect.
So,
Nikhil, I expected you, after your email yesterday, I expected you to jump up and ask that question before we started.
no, I mean, I feel it would be in interest of everyone, because I guess compliance is a big question mark for everyone. So, to summarize my question, it is basically that based on the use cases, or like we have these purpose codes and eventually they'll get better fleshed out. So do you think compliance would be standardized? Like, for instance, somebody asks that with a RA license can you do lending? So would the PFRDA say have a different set of compliance rules in place for such use cases?
Yes, every regulators, every license would have a different set of compliance rules. There's no harmonization there. What would happen would be that it would be an ideal opportunity for a company to start automating that entire compliance process, but it will be a painful process.
Right. It sounds like a good use case. Maybe I'll take it up.
Yeah, and it's a big opportunity. I must tell you, there are lots of other startups trying to harmonize compliance in various other sectors. It's a huge market.
Right.
Right, and with Mahesh and Aryaman doing such a fabulous job in making this more and more popular. You can start with the AA ecosystem. The NBFC AA compliance is really, really painful.
Definitely. Yeah. Thank you.
Yeah.
So the second part of his question, of Nikhil's question on the chat, which is, how long would it take to get like an RIA or RA license? Could you shed some light on that?
No, I think Ankita should. This one's her forte.
Yeah, so
What was the easiest one?
a registered investment advisor license before COVID could take anything between 1 to 2 months,
Okay,
based on your compliance and the infrastructure and the people on the board advising and who would be undertaking the investment advisory.
right.
Similarly, a PFRDA license was fairly quick. It could actually be, you could actually get it within 3 to 4 weeks. But now I understand there are a couple of issues because if you want these licenses, you need to be NSIM registered, should have gotten that certification. So you will need to undertake the exam. I am not sure what the position on conducting those exams right now is with the ongoing lockdown. So I suspect, as of now, we could at least expect these timelines to increase twice.
Oh,
We're
okay.
looking at least 3 to 4 months, possibly.
So you need to pass an exam in order to apply.
Yes. So the people who will be undertaking the advisory services, one or two people within the team have to be NISM registered. So you need to pass a securities examination conducted
Okay.
by one of these institutes.
Okay, and then it's possible to, for example, obtain a license to be a retirement advisor, but then, as some of the people were saying in the chat, access data pertaining to different, assets like insurance or different things, and use different purpose codes. There's no limitation on the purpose code, because if you're
Absolutely
regulated,
not.
you're not obliged to do the retirement advisory. You could just be a regulated retirement advisor, but then operate as a PFM app for a vendor or whatever you want.
Absolutely.
Okay, great, thank you. So, guys, you need to start studying or hiring lawyers for this exam.
Right. And also, I think, 2 weeks back or so, the net worth requirements and rules have changed around the RI, which will be effective soon. So,
Yes.
yeah.
I think in good times, once the coronavirus is done, the popularity of the PFRDA license will come back. And I think most people who want to become an FIU would go for that because they really are, even in terms of compliance, the easiest to comply with. Ankita, step in if you disagree, but even
No,
on
I absolutely, I agree with you.
the PFRDA is the easiest to do. So you should look at it not only from the perspective of how quickly can I get it, but also from the perspective of once I get it, how much of a difficulty is it maintaining it?
So I'm just knocking off some of the questions which have already been answered. And Kantaraju from Perfios had asked a question, if you become an RIA and hence an FIU, can you only do RIA activities and nothing else with the data? So we just answered that, which is that no, you can do, non-RIA activities as well. And then there's a few more questions, so I'm just going down from the top. Nikhil, do you have any more questions?
No, actually, I can't find the leave stage button.
Okay, don't worry. I'll get you off. Thanks.
Yeah.
So Neil is coming on stage.
Perfect.
Hi, Neil.
Hi. So, like all things being like normal, like where there are no added complications or regulatory gymnastics required, how long do you think making an application takes to either the RIA or either for an RIA or for an RA?
Neil, that's a fairly quick process. So, unlike most of your NBFC licenses, the investment advisor licenses are fairly quick. Of course, there are a lot of details that need to go into the application form with respect to the entity that's applying, the shareholders, if you have any other shareholding in any other companies, or other directors on boards of other companies. So there is a lot of detail that needs to go into it. But the application forms, to be honest, are fairly simple. There are a couple of deeds that the directors and the shareholders are expected to sign, a few documents to attach with the application that needs to go in. But all in all, I wouldn't say it's too complicated.
Okay, understood. Thank you.
Thanks.
Anyone else? I think, let me start from Swapnil. I think has asked this question a while ago, which is whether there will be a conflict of interest for an AA becoming an FIU, providing over-the-top data enrichment services or credit score APIs, because then the FIU has to be some sort of an NBFC or PFM regulatory body. That's a complicated question. There might be an element of a conflict of interest there, but there are fairly easy ways to sort it out. Perhaps we could, a little bit of corporate structuring here and there. Perhaps we could take that offline, because that may not be relevant to most of the others. Anyone else wants to pop by with a question?
There's one quick question from Manmeet. Can an individual with RIA become an FIU, or FIU is restricted to a company? So Manmeet, it's only a company that can become an FIU. So even if you have, like, for example, those individual insurance agent registration, or if you're an individual that's registered with the SEBI or the PFREA, you wouldn't be able to become an FIU. The RBI is fairly clear on that. Only companies are eligible to be FIUs.
There was one. A lot of the teams in this hackathon are working on a use case to anonymize or otherwise, enrich user data. So they take data from an existing FIP, and then they do something to it. They transform it, they filter it, they add to it, and then not. The intention is not to use it themselves, but then to be a proxy to get that data for other FIUs. So in the first instance, they are an FIU and they request data from an FIP. Then they take that data and they do something with it, and now they have the customer's data lying with them in the transformed or enriched format. And in the second case, they become the FIP, providing that transformed or enriched data to an FIU. Is that something which can be done, and if so, how?
Yeah, so I mean, in fact, I think probably, was this the discussion during the hackathon, Aryavan?
What do you mean during the hackathon?
Yeah, a discussion that came up in the last 2 weeks.
Yes.
Okay, because I had a 1-hour-long conversation with Mahesh on the same topic this morning. When we use the word FIU and when we use the word FIP, these are regulated terms, right? These are terms which are defined by the RBI. Therefore, an FIP is a bank or an NBFC. It's not anyone who provides information, right? An FIU is a regulated entity that is attaching itself into the pipe and kind of deriving data from them. Now, if you act on the data that an FIU gets, and you kind of have a new data set or a new analysis or a new product built on that data, and that involves and incorporates that data, and that data is now going to be, or that result is now going to be piped to other fintechs, or is going to be distributed to other companies that pay the FIU money. Right. That is something that is possible. However, that is something that requires fairly great working of the consent system. So apart from you can't just plug into the AA architecture, right, not be clear to the customer that you are going to use their data to do 1, 2, 3, 4, 5, 6, and then go ahead and do it. However, if you take proper consent from the customer on exactly what you're going to do with this data, including the derivatives, or alternatively, if the data is effectively aggregate data and not personal data, there are multiple ways you can play this, but all of them would have to conform not just to the RBI's rules, but also to the Personal Data Protection Act or the Reasonable Securities Procedures rules, depending on when you do it, so that it's consistent with law. So short answer, can do it, but need to do it in one or two particular ways. That's the only way you can do it.
Makes sense. Thank you.
Okay. All right. Here's an answer that I don't have from. Here's a question for which I don't have an answer. Ankita, do you? This is from Perfios.
Yeah.
They want to know whether it's necessary that the RIA license holder is a full-time employee of the FIU organization, or can the license holder be on a contract?
Great question.
Yeah, I may not have the answer. Do you, Ankita?
I suspect the person that's providing the advisory services, or at least whose details we are putting in the application form, would have to be a full-time employee. Because then, in the absence of that person, the RIA wouldn't be able to carry out those services. And that means it wouldn't comply with the eligibility criteria and the registration norms.
Yeah, so let Ankita go back and argue on this a bit. It's a new question. We've not faced it before, so we'll come back to you on that. What I'll do is we'll drop you an email. Shall we move on to, are there more questions on FIUs, or should we move on to the slightly more complicated account aggregator license? Ankita, do you want to take them through any of the compliance processes after this, or shall we just go to the AA architecture?
We can we can get started on the AA application process. I think that would be a couple of slides as well.
Perfect. Let's move on.
Okay. So like we discussed yesterday, there are a few specific compliance requirements for an AA, especially one being that an AA cannot carry out any other business other than the business of account aggregation, which means all the questions pertaining to whether an AA can undertake other activities will have to be structured in a manner where it's through either a different entity or through some corporate structuring, where it does not affect the AA's business as such. So that's fairly important. Right, and of course, the AA needs to ensure that it's the IT framework's fairly robust, the security systems for the transfer of data between the FIPs and FIUs is fairly secure. So there are a lot of detailed compliances on those bit. Now, from an application perspective, the RBI doesn't have very detailed requirements to begin with. There are some overarching principles that the RBI has prescribed, at least to evaluate whether it should grant an in-principle approval or not. One, of course, being whether you have the necessary resources and the technology and the knowledge to be able to carry out the AA services. The character of the management, the proposed management, the board of directors is something that the RBI looks into very carefully. So we've often had a lot of questions from the RBI where there have been applicants with or without not too much financial background or experience. The RBI has come back saying how they intend to carry on this particular business without having enough background on the industry. So we understand that this is something that the RBI looks at very closely when you make an application for an AA license. You, of course, need to comply with the 2 crore requirement. However, this is not an immediate compliance requirement. Once you are granted the in-principle approval, you have 12 months to be able to put together and make sure you comply with the net worth requirements. You need to have a fairly detailed, robust information technology system. Very, very important. There are some basic compliance requirements and declarations that are needed from shareholders and directors. This is what the RBI calls fit and proper criteria, which means there are no disciplinary actions and proceedings against you. You will act in your fiduciary capacity, not have any prejudice or biased judgments. These are deeds that need to be signed by directors while submitting the application form. Now, going to the application process itself, right? So you have an entire application process under an application form under the RBI regulation, which is a very, very detailed data-specific information about the entity, the shareholders, the directors, if there are any other subsidiaries the entity has, whether the entity has applied for any other license from any other regulator which has been approved or rejected, the entire share capital structure, if the directors are on boards of other companies, who is the parent company of the entity. So a lot of information about the entity per se, the shareholders and the directors, and of course documents that need to be sent along with this application to with this application, such as like your educational certificates and your CIBIL scores that need to be accompanied by this. Now, while the application form that the RBI has prescribed in the regulations is fairly straightforward and needs to be supplemented with your financial statements, what's also important is to make sure you accompany the form with a fairly detailed, thorough business plan. And when I say business plan, it's not only from a financial perspective, it's also an overview of the entire IT framework that's going to be put in place. How the AA would develop its own client app, the customer facing app. What are the security processes that the AA would put in place? What are the encryption mechanisms that are being used? Right, the entire technology framework and the interaction between the AA and the FIU and the AA and the FIP needs to be laid out very clearly in your application form. Now, once this form is submitted to the RBI, it could take anything between 6 to 12 months to get the RBI to either grant the in-principle approval, send back the application for lack of clarity or seeking more information, or reject the application. Now, in our experience, we usually find that once you file an application, usually within a month and a half, I would say 30 to 45 days, you would hear back from the RBI, where they have evaluated your application with at least the basic details right there. And they will probably come back to you asking more details on things that they suspect they need more clarity on. Right now, based on whether this is a financial or a business aspect or something to do with the directors or the shareholders, their questions could vary from the entire shareholding capital of the company to who are the directors, more details about the directors. It could also be something that's very specific in terms of how do you intend to acquire customers and your your pricing policies. It could also be, give us your entire business plan for the next 3 to 5 years. So based on the entity that's applying for this particular license and the information that's been supplied, wherever the RBI feels that it needs more details to evaluate the credibility of this particular organization, they will usually in a month and a half or two, come back to you asking more details. But of course, hearing back from the RBI with respect to an approval will take much longer. There are a couple of clients we know who haven't heard back despite 12 months of having applied for the license and submitting all additional documents that the RBI wanted. Right now, once you get the in-principle approval, of course, your approval is valid for 12 months. Now, once you get the approval, you need to make sure you comply with all the other requirements that the RBI mandates, which means there are requirements from a corporate governance perspective. You need to have some nomination committee. You need to have an audit committee. All these committees need to be set up. You need to appoint directors and members for these committees. You need to, of course, meet the net worth requirement if you haven't met that already. These are all post-approval compliances. Once you comply with the post-approval compliances, and you've practically ticked off all the obligations and compliance requirements that the RBI regulations prescribe, you need to go back to the RBI, submit all this information, and it will grant you an operating license. Now, let me quickly touch upon what these compliance requirements are without getting into too much detail. From a data security perspective, you need to give a lot of information to the RBI on your entire IT system. What are the mechanics and the steps that you've incorporated to ensure that the information is protected? There is no unauthorized access. There is no possibility of there being any destruction or alteration of the data that's being transmitted. Right? What are your measures for disaster risk management and business continuity that you've put in place? You need to undertake an information system audit for your entire internal systems. Like I said, the entire technology that is being used, the encryption mechanisms that are being used need to be very clearly spelled out and put in place. The RBI has its own checklist for technical specifications that it requires the AAs to confirm and abide by. So it will require you to make sure you have access control systems. There is two-factor authentication for certain files that are stored. So it will prescribe certain additional technical specifications once you get the in-principle approval. From a corporate governance perspective, like I said, there are a couple of committees that need to be set up to ensure that the AA is being managed in a fairly robust manner. Like the management is looking into the affairs of the AA very carefully. So you have a nomination committee, you have a risk management committee, and you have an audit committee. You also need to ensure you have a few important policies, especially with respect to the customers. So you need to have something that's called a citizens charter, which lays down the rights of the customers against the AA. You need to have a fairly detailed customer grievance policy where customers can reach out to you should they have any complaints with respect to the entire financial information that's being transmitted, or if they've given a consent and they've tried to revoke the consent but information is still being used. So you need to have a detailed grievance policy and management system. You need to, of course, have an entire pricing policy that the RBI mandates should be put up on your website. Then moving on with respect to the third-party service providers that the AAs use. Now, you of course need to, the AA needs to comply with the outsourcing guidelines by the RBI. So the RBI has directions on the code of conduct for outsourcing financial services. Now, while these financial services, the code of conduct is not a very recent code that's been introduced by the RBI. So references are essentially with respect to lending and other material outsourcing activities. But it's fairly clear from the AA regulations itself on what can be outsourced, what cannot be. So if there are any technology related aspects that are being outsourced, as long as these are not material to the business and the entire business of aggregation, and as long as it does not affect the security systems, these should be allowed. You need to undertake, like an AA needs to undertake periodic assessments of all their third-party vendors, make sure whatever obligations are imposed on the AA, they are being followed by these third-party vendors, evaluate their security systems and technology in place, make sure the cyber security risks associated with these vendors have been taken care of by them. So there are a lot of process requirements for an AA if they are going to be outsourcing any activity to third-party service providers. You also need to make sure you have proper detailed agreements. So be it with the customer and the service that you're providing to the customer, and the agreement that an AA needs to have with the FIU and the FIP, that needs to be detailed and put down into writing. One important question that often comes up with respect to an AA is whether they can get funding, right? Now, the RBI has fairly detailed change of control norms for an AA, which means that if there is any takeover or any change of control or an acquisition of an AA, you need an RBI, you need a prior consent from the RBI. Now, there are multiple aspects that the RBI, in RBI's opinion, could be a change of control. So even a change in management of the AA, which would result in more than 30% of the directors being changed, would be a requirement where you would have to go back to the RBI and get permission. Similarly, if there has been a change in the shareholding, an acquisition or a transfer of more than 26% of the share capital, then you need RBI's prior consent. If you are going to give your directors voting rights for the meetings and decision-making rights, you will need prior approval of the RBI. So if you are an AA that's looking at investment from funds, then you need to ensure that your corporate structure is set up in a manner where change of control at the parent entity level would not affect the would not affect or cause any change of control at the A level, so that you could continue to function and you wouldn't have to go back to the RBI for consent every now and then. Okay, do we have any questions on this?
Yeah, Ankita, I think there's one question that has come from Neil, which is whether there is a particular format for a business plan.
No, no, Neil. So there isn't a particular format. You are, of course, as a part of the application form itself, required to provide financial statements as on the date that you submit your application. With respect to the business plan that you submit along with the application form that provides the entire overview of the infrastructure and the tech in place, there is no format. It's you basically informing the RBI on what are the protocols you've put in place and how your entire aggregation system would work and how the AA would integrate with the FIPs, FIUs simultaneously, and the customer facing app that they will create. So it's an overview of that. In some cases, of course, the RBI may come back seeking more information, but that would solely depend on what's been provided and where it feels there is some ambiguity or lack of clarity.
Perfect.
Does that answer your question?
Well, he can't answer because he's not on the speaker. But is there any other questions that you want to interrupt with now, or should we just go on? Ankita, go on. I think they'll wait for questions. Oh, there's one more question. I understand that the RBI, this is from Vivek from Capital Flow. I understand that the RBI guidelines clearly mention that the AA cannot access user data. But I have also seen a discussion that AAs can build a client app. Okay, so let me explain this to you, Vivek. What happens is the AA is just a pipe. Now, a user can see user data on a client app that the AA has built, but that data will reside in the app itself. It will not reside in the app, will reside on the phone or on the laptop, I'm guessing. And therefore, the AA continues to be data blind. Does that answer your question, Vivek? Do you want to pop on, Ariman, do you want to pop on, do you want to invite Vivek onto the video? Because I think this is the question worth spending some time on. It's something that keeps coming back.
I can, if he raises his hand, I can do that.
Sure.
So Vivek, just to add in there, like Matthew said, while it can show a customer the information that's residing with the financial information providers, the entire process is encrypted. The de-encryption happens only on the user's device or the platform that they are using. So the AA still cannot at any point of time know what this information contains.
I guess Vivek, I'm guessing this is Vivek from Walnut. I guess Vivek does not want to speak. But anyway, anyone else? So Ankita, do you want to take them through some of the timelines, the responses that we've received from the RBI, the concerns that we've got from them, what is the level of detailing on the disclosure, something more practical than what the law is?
Sure. So, like I probably mentioned in the last few minutes during the discussion, there are a few aspects that I believe that the RBI looks at very closely. One, of course, being the management of this particular entity that's applying for a license. So it will look at the credentials of the shareholders and the directors very, very closely, which means you will be required to submit experience letters, you will be required to submit all your previous jobs, leaving certificates to as support to with the application to inform the RBI of what all work you've done in your previous jobs and how you are fit to be a director for this particular AA. We also realized that the RBI focuses a lot on the tech and the infrastructure aspect of an AA and the business, right? So while of course it does allow applicants 12 months timeline to be able to comply with the net worth requirement once you get an in principle approval. It will seek a lot of information on how the company intends to acquire the 2 crore requirement and how does it intend to get this funding in the next 12 months. So while there have been clients and there have been companies who've gone ahead and applied it, some have managed to get an in principle approval, while some are probably still waiting. The RBI focuses a lot on how do you intend to meet the net worth requirements if you haven't already done that at the time of submitting your application. So whether it's through investments, whether there will be an infusion that needs to be discussed and detailed and outlined to the RBI in your business plan or as a part of the application process. The other aspect that the RBI will look at very closely is your credit reports. So in our experience, we've realized that the RBI ends up, in most instances, asking credit reports for not only the directors and the individual shareholders, but also the entities. So if you have a parent company that has 100% shares in the AA entity, the AA entity as well as the parent company or any other subsidiary that you have or affiliate that you have will have to submit CIBIL reports to the RBI. All in all, I understand that the approach is to just verify the credibility of your business and the people managing this entire entity with respect to the aggregation business.
Right. Perfect. We have a question from Avinash. He wants to know whether the AA can store data on the user's behalf. Ankita, or should I? Okay, I'm guessing Ankita dropped off.
Yep.
Maybe she didn't like the question. But anyway, so Avinash, the rules are very clear. The AA can only do the business of account aggregation. It can't do anything else. So if the AA wants to help store the data, use the data, process the data, there has to be a complicated structure where it's either an affiliate or a company owned by the same owners as the AA who does a slightly, different variation thereof. The AA is only allowed to have a client app where it can show the data. That's it. Right? It can't store the data on behalf of the AA, of the client. I hope that helps. Hi, Ankita.
So I think there's one field which it might be interesting to touch upon, which is that there's of course regulation in this ecosystem, led by RBI, and there are some. I don't know if I would define them as illegal, but yeah, I guess I would say there's some legal sort of documents, right? The RBI Master Directive and things like that. And there's also Sahmati, which aspires to be an SRO, and there's a different kind of, I don't know if I'd call it regulation, but I guess my question to you, Matthew, is how should one look at it from a legal perspective? I mean, is it the same, the authority of Sahmati and the authority of RBI? It might be useful for people to understand that as well, the way in which these two kinds of authorities play into each other.
Yes, so the mother lode is the RBI regulations. Everything flows from that. Eventually, that there will be something on top of that, which will be the data protection law that will come up. But right now, the mother lode is the RBI. Sahmati gets its power from being, or its regulatory noose from being a collective. So to that extent, Sahmati is voluntary. Sahmati's regulations are at this stage not having the force of law like the RBI does, but has the force of law in the context that it is persuasive, everybody's adopting it, everybody's working with Sahmati. So the model contracts, which is what I'm guessing you are referring to, will hopefully be adopted by the industry, still won't have the force of law, but will have persuasive ability because everybody is adopting it. Does that kind of answer your question?
Sure. Should we, go into the model contracts a bit so people are aware?
Okay, Ankita, do you want to take them through the model contracts and how we drafted them?
Sure. Happy to do that. Now, from a model contracts perspective,
Before you
what
start,
we've
Ankita, just to clarify, the model contracts are work in progress. We are trying to, Sahamati and Mahesh and Aryaman are trying to build consensus across all of you that the model contracts between, which are recommended contracts between FIUs, FIPs, and AAs, reflect the most fairest standard for the contract, right? But with that, Ankita, go on.
yeah. Sorry, just give me a second. Yeah. Now, from a model contract perspective, at least between an AA and an FIU, we've tried to capture the essence of the service that's being provided by an AA. First, of course, there being an entire obligation on both the parties to make sure they comply with the technical specifications. Right. There are significant obligations of an FIU to make sure that they use the information that's been collected solely for the purpose as per what was agreed in a consent artifact. I know we'd kind of touched upon this particular aspect in our previous discussion as well. Going back to that aspect once again, a consent artifact is basically where a consumer agrees to the information that's being shared. There is a particular format or a detail or details that need to go into a consent artifact. So the identity of the customer and the contact information, the nature of financial information that's being requested by a particular FIU, the purpose for which this information is being collected, right? The identity of the recipient of this information, how the customer would be informed every time there has been a particular access to financial information based on the consent that was given, the consent creation date, the expiry date, all of these aspects need to be clearly spelled out. Now, since these are the parameters through which a FIU can actually access and use this information, it's very important to ensure that from a model contract perspective that these FIUs strictly comply with the consent artifact. And should a customer revoke consent through an AA, the processing of this information is stopped immediately. Right now, when a customer chooses to withdraw consent, the FIU, of course, should stop processing. We've already debated and have had a discussion on this in a previous discussion. Probably we'll touch upon this in the next session as well with respect to whether an FIU can continue to store the data that it has received already. So can it still continue to store the financial information it had received based on previous consents? What's also important for FIUs to evaluate is that whether their service gets affected once a consent is revoked. Those are aspects that need to be very clearly spelled out between an FIU's contract with the customer. But from an AA and an FIU perspective, the obligation is very clear that it needs to comply with the consent artifact. What they also need to do is, under the new law, we've tried to ensure that from a model contract perspective, the data requirements and the security standards are clearly met out. So when there is a right to revoke, then that must be communicated to the FIU immediately. Similarly, if there is a security breach at the FIU level as on date, the FIUs should notify the AA, and then the AA can in turn notify the RBI. Like Nikhil said, and we discussed earlier during this session, there aren't changes to the regulations that govern different FIUs with respect to their involvement in an AA ecosystem. So a lot that's being done is through the AA. How a FIU should comply or participate in an AA framework or the entire ecosystem is not something that comes from the FIU's legislation, but the AA's legislation, which is why if there are security breaches at the FIU, an AA must be informed as it pertains to the AA's customer information. Right. We've also tried to allow inspection and audit rights with respect to an AA, but I suspect there has been some concern from FIUs there. Given that there is no way for an AA to evaluate how the information is being stored and whether it's actually being shared with other third parties, as mentioned in the consent artifact, it's very difficult to verify the compliance of an FIU with the consent artifact. This is probably something that will develop and evolve once we have an SRO in place that looks at all these aspects. Right, and then of course the additional aspects that go into model contract between an AA and FIU is of course with respect to termination of their arrangement, the liability that an FIU takes up if there is any fault of an AA. There are instances and there are use cases we are discussing where should an FIU not receive the accurate information that it had requested for by an FIP, who should their action lie against? Is it the AA or is it the FIP directly? These are issues that we are trying to address through the model contracts between an AA and an FIU. Similarly, with an AA and an FIP, the model contracts essentially focus on trying to ensure that the data is shared on a real-time basis, right? The mechanism and how the credibility of an AA needs to be verified. So the RBI regulations put certain obligations on a financial information provider. When a financial information provider is to share information, they are required to validate the consent that was shared by the AA. They're required to look into the credentials of the AA. Right now, while these are obligations that are imposed on the FIU, how these aspects need to be verified is something that the RBI hasn't gotten into much detail at this stage. But only once the FIP is satisfied with the credentials of the AA and the validity of the consent, will it go ahead and digitally sign and share the information to the AA to be passed on to the FIU. Right now, we always have we see this question from multiple entities on what's the differentiating factor between one AA and another AA. And probably if we have someone from from any AAs within the attendees, it'll be good to hear from them. But the idea is, of course, their entire user base, their interaction with the customer, their value-added services that are being provided along.
Oops. So I'm assuming she'll be back shortly when the network resumes.
I hope so as well. But anyway,
So, I mean, I can answer the same question from a slightly different perspective, not in terms of the different kind of. I get this question a lot, right? Like, if AAs all provide the same thing, which is the same data in the same format, then where is the differentiation? I think one thing the hackathon is showing us is that, different AAs have different approaches in terms of how they build out their software. So whether you're an FIU or an FIP, the software provided by an AA can be different and do different things. For developers, the experience can be very different according to how AAs write their APIs, their SDKs, their sandboxes, etc. And a big difference could be something like UX or reliability. Payment gateways are all fundamentally very similar types of companies which have identical offerings in most cases. But there are some payment gateways which stand out because they have exceptional reliability and UX. So those are some differences. So Ankita, sorry, you got cut off when you were describing the differences between AAs. And I guess she fell off again.
I guess so. Yes. So cool. I mean, I think by and large, that kind of gives everyone an overview of the architecture, regulatory wise at least.
Hello.
Hi, Ankita. I was just going to pop up and say, is there anything else you'd like us to cover, Aryan? Or do you think there'd be more questions? I'm sure this is going to be work in progress. So if anyone wants to pop by with questions, they can always, you have my email ID now, you can always pop by. But are there any specific issues that have come up that you think we could help out on?
I think
Everyone's
maybe whenever contracts are ready, we could release those, and that could be something
So the
for the
contracts are
ecosystem.
kind of ready. Do you want to invite Mahesh on to kind of talk about progress and all of that?
Sure. Mahesh, are you there? Awesome.
Not sure if you can see me. Maybe
Yes,
no.
Mahesh, we can see you.
Yeah, so have the contracts between FIP, AA, and FIU and AA, okay, which have been developed with the help of Spice Route, and it is being shared with the institutions which have implemented the FIP and FIU module. So it isn't something which we are uploading on the website and making it, like open source, but we will share with only those institutions which will, first show us that they have implemented the FIP and FIU, and it has been first shared with, all the account aggregators. We got, all their feedback, and afterwards it was shared with all the banks, and their feedback also has been incorporated, but nobody is under any obligation to use uh, the uh, your template, which is with us. So
So
each institution, if they want, they can use something of their own or use what we have, as a starting point. But we encourage them to use in the one which is with us, okay, because it is somewhat agreed upon by the ecosystem.
right, okay. So
Something else?
Mahesh, my question was if the FIUs want to, or the middleware providers want to get a copy of it, should they write to you?
Yes.
Mahesh, yep,
Yes,
there's
Ankita.
one question.
Yes, Ankita.
Vivek from Capital Float is asking if there are any guidelines from the RBI, SEBI, or IRDA on how much the FIPs can charge the user to access the data via an AA or an FIU. Would you
Yeah,
want to share some
currently
thoughts
it
here?
is, yeah. So, yeah, no, like if an FIP wants to be actually, you're charging and like actually consumer, they're free to do so. But as of now, all the banks have agreed to provide the information for free. But obviously, I mean, if the amount of the data, the frequency of the data, which the FIP has to be providing for a particular user, if it increases a lot, the FIP is free to charge a customer. Okay, so the RBI is not having anything to say that you can or you should not or you can't actually charge the end consumer. And about the pricing, what the AAs are allowed to actually charge the FIUs, it won't be regulated as of now. So it is up to each of the account aggregators on having their own pricing structure.
Yeah, I think I agree with you, Mahesh. I think the RBI doesn't want to get into pricing. Neither do
Yeah.
you, right?
No, no, no. I mean, I think we have enough on our plate
Enough
now.
things.
Yeah. So, yeah, market will decide.
And I'm guessing also pricing should also depend on the services provided, right? How quick integration, all of that should differentiators, market feedback, all of that should come into pricing. None of
Yes,
our.
exactly. Yeah. The market will actually know within few months, which AA is good, which AA app is, smooth, sexy, if it has Indian language, the thing, if it has voice support, all of that. It's up to each AA on, how fast they will be able to have something which the end user actually wants.
Yes. So the only thing to keep in consideration again, okay. Jigar from Nets AS says this is strange because FIP don't charge for accessing NetBank. Ultimately, same data is provided via API. Mahesh,
Sure.
not
Yeah, I'll tell you. Okay, see now. How about I give you examples? Like and like actually, bank will say 4 withdrawals from ATM every month is free, and from the fifth one for each one you'll pay about 5 rupees, 10 rupees or so. Now the same information you are exactly all right. If you go on the internet banking, you will be able to get the data. So you will have to download the data and okay, and then upload it on an FIU, which is we are already doing that, but it is not a very scalable way of to do things. One, and number two, you would agree that it requires the human intervention. So the whole idea about AA is that once you give the consent, automatically all the information from all your FIPs will reach the FIU in a consented manner, and all the information which the FIU will receive is in a machine readable format. But when you upload a PDF, okay, so then the FIU will have to screen scrape it. Okay, and in the AA world, all the information which will come from FIP to FIU will also have the digital signature of the FIP. But when you upload your PDF, and if you have excellent creative skills, which we all have, you can always change your balances. Okay, so for the FIU, will slowly insist, okay, that they want to get the information, from an FIP only via an account aggregator.
So, Abhav from SpeechMind has come up with a question, Mahesh, that is, I know that we have discussed many times in the evenings, which is basically if AAs charge the FIUs, why aren't the FIPs charging the AAs? And I'll again leave it to you because this is.
Yeah. Okay, so see, the FIPs have been, very, very kind enough, okay, to say that initially FIP data will be given for free because they want this ecosystem to thrive. Okay, the more and more hurdles if you are going to have in the beginning, okay, so then the lawyers will have excellent business. Okay, we will leave that. Okay, but for the ecosystem, it is very, very important that we are easily able to get the data at no charge for now. And see, on the long run, it is actually good for the FIU also. See, all FIPs are FIUs. So if FIP isn't actually charging, so even the cost on FIU is not increasing. So that same bank is also acting as an FIU, which will be going to use various other FIPs. So that FIU is again not being charged. So overall it will be it will be fine. I'm saying the FIP will give for free, but of course if you are sitting every day and requesting like your terabytes of data from your FIP, you will be charged, and you should be charged.
Perfect.
Okay.
Are we all out of questions? Anyone else got anything before we kind of wind up? When is the next session, Mahesh?
It should be, we'll ask the Mr. Ariman.
Yes. So our next session is, I believe it's on Saturday at 3 p.m. So we have a session which will, it will be in a similar format where we'll take questions.
No. So it's on Wednesday again. We have, right?
Oh wait, the next session with Matthew or
the
overall session with Matthew? Which one did you mean?
Yeah, no. I meant the next session. Like, what's up next?
Okay, so the very next session of the hackathon is at 6 p.m. on Wednesday. We have Rajesh Kumar, who's the CEO of TransUnion Sibyl. So he'll be talking about risk.
Yeah.
So that's on Wednesday. Yes.
So this is the last one for today.
This is the last one for today. Yes.
The only one, I guess.
The only one. Yeah. Today is a light day.
So you're special, Matthew.
You're feeling very special, yeah.
But Matthew,
Yeah, we wanted to ruin your Sunday, so we said we should get you on the Sunday.
I don't mind, that's part of the job, but all these people's Sundays are also ruined listening to some legal mumbo jumbo.
and next Saturday there will be more. So we have another session next Saturday with Matthew at 3 p.m. On Saturday the 25th. So everybody who's watching this, as you know, everything is in the Hack Bible and on the Sahmati website. So please do stay tuned to that for all updates, and we'll put stuff on Slack. But
So I've shared the link already.
yeah,
Perfect.
okay.
And that's on data law and the architecture. Hopefully that'll throw up far more interesting questions than how to apply for a license.
Well, I think it's very important and necessary either way. So thank you very much, Ankita and Matthew. Thank you everybody who's watching, and we'll see you on Wednesday. Thanks everybody.
Perfect. Thanks.
Thank you, guys.
Ew.
Bye.